Um, our speakers today are Bill Grobe and Iggy Garcia. I've known both of these gentlemen for many years. Really great experts on their topics. I remember I think Bill was one of the very first presenters I ever saw. I hope I don't make you feel too awkward, Bill. When I first started practicing on non-competes, which I know a lot of startups get, either trying to make sure they can enforce their non-competes or other issues. So, whatever issues you're having with them, these are definitely the people you want to talk to. And then Iggy, known him for many years as well, just both very, very expert level knowledge on any of these employment issues. Both have received multiple awards. I saw Iggy's here today, and just lots of great accolades and everything, and definitely well deserved, all of it. So I'm going to stay on today to advance the slides, and I'll try to not pipe in and give my own opinion. Those that know me know I'll talk all day. So I'll try to turn it over to Bill and Iggy. Cassandra, if we can bring them on stage. All right, I saw Bill here and Iggy. Bill and Iggy are what you can see. Is the screen share up as well? Or do I have to hit that now? I believe I have to hit that. Let's do that. So we have our slides up for today. If you want to, maximize the size of the slides, I was commenting with Eric, my counterpart for the track captain. It's interesting to see how startup folks differ in presentations from us attorneys. We're very PowerPoint fact driven. So, but if you're ready to get a lot of information from two incredibly expert level attorneys, they're from Ogletree Deakins Tampa office here in the Tampa Bay area, both just really great and very active in the community. I suspect neither of them sleep, or they may have figured out how to clone themselves, given the schedule and all the places that I see them do, and all the things that they're just incredibly gracious to us and our organization as in-house attorneys, a nonprofit organization. So with that, I'm going to hand it over. I'm going to mute myself and turn off my camera so I don't distract, and I hope you guys enjoy this information. Thank you.
Thanks so much, Matt. I'm Bill Grobe with Ogletree Deakins. I'm a shareholder along with Iggy Garcia. Matt, go to the second slide, please. The Iggy and I are very similar in our practices. We both have a national practice. We practice all over the country and have clients not only domestically, but overseas as well, in Europe and Asia and other parts of the world. And so we're very lucky to be able to have our finger on the pulse, really, of what's going on not only in Florida but in other states and other jurisdictions. And it gives us the opportunity to see, especially for those of you with a multi-jurisdictional footprint, it gives us the opportunity to know what's going on across the country and throughout the world. And so we're going to talk to you a little bit today about what's been going on recently, especially in light of COVID. What are the things that we're seeing both in the workplace, and what do we expect to see on the horizon? I'm going to start out. Iggy and I are both in the Tampa office. I'm a trial lawyer, so I've tried cases all over the country. Iggy has tried cases as well all over the country. And so we get to see juries. And what I always think about is, what is the jury possibly going to think about the decision that my client is making, and how will it look both optically and from a legal standpoint? Because our job is to make sure that your case never goes in front of a jury. So we want to make sure that you're taking the right steps and doing the right things, dotting the I's and crossing the T's, to ensure that you don't have an issue. Anybody can sue you for any reason whatsoever. It doesn't mean that that suit has any viability or that there's any truth to it, but it also doesn't mean that someone can't bring a false claim against you. And my job is to make sure that if someone does that, that we get the court to kick it out before the jury ever sees it. So we think about those things as we move forward today, and we'll talk about them. And if there's anything that we can do to prevent lawsuits, then we want to make sure that you have that information. And I know it's startup week, so a lot of you are starting businesses or expanding your businesses, and we'll give you some ideas on how to treat employees. A lot of things that you hear, Samuel Clemens, Mark Twain said, believe none of what you hear and half of what you see. That's generally true. A lot of things that you hear about what's enforceable and what's not enforceable is probably not completely accurate. we'll try to give you a more accurate picture, especially in light of COVID and the idea of people working remotely and then returning to the workplace. Next slide. And so we're going to start out with COVID-19. I'm going to tell you a little bit about what's been going on in the world with regard to COVID-19 in the workplace. And then I'm going to talk to you a little bit about what's been happening in the world of litigation and the Supreme Court and what are laws on the horizon. Then Iggy's going to talk to you about some additional best practices and what we can expect in the COVID-19 environment as we move forward from today on, and things that we're seeing with regard to trends as we go forward. And he'll tell you a little bit about himself when he starts up about halfway through the presentation. Next slide. And so I thought this was interesting. I saw one of these face mask exempt cards, and I thought, wow, that's really cool. Is this a thing? No, it's not a thing. It reminds me of when I was a kid, and you had like these magazines. You could order these fake IDs in the back of the magazine. Of course, the only reason me or my friends ordered one is so we could vote. But the other people ordered them for other reasons, but they'd get this fake ID, and it would not look real at all, and it would look like a fake ID. But for some reason, people tended to play along with them and say, "Oh yeah, that's cool, that's good." Well, this is not a face mask exempt card that is anything that's really viable. I think that it was probably started by members of the plaintiffs' bar in order to drum up business. But if you see one of these, people may be exempt, may not be exempt, but it depends on what their condition is. And if there's a condition that makes them more susceptible to the dire consequences of the virus, or for some other reason, then maybe they are exempt from face masks, or they can't wear a face mask for that reason. But I encourage you all. Some of my clients have said, you know what, we're going to have a zero tolerance policy on face masks. We don't care about the ADA. We care more about public health and safety. We think at the end of the day that the public is going to err on the side of safety than erring on the side of someone coming in and saying, I can't wear a face mask. And our response is, that's fine. We don't know what the courts are going to say about this for companies that take, especially here in Florida, right, where we have the tourist mecca of the world and represent companies like Disney World and SeaWorld and Universal Studios and Clearwater Marine Aquarium, Tampa Bay Buccaneers, all of the venues that we have down here. Some of these venues are choosing to take a zero tolerance policy. You must wear a face mask or you can't come in regardless of disability. But I encourage you that if you do have such a policy and you put in such a policy, then make sure you have at least one alternative, and that's a face shield. Right. So at least if you have face shields, you do have an alternative to the face mask. Those individuals who may, for whatever reason, because of a condition that they may have that may not be able to wear a face mask, likely may be able to wear a face shield, and at least you have some other alternative rather than just the one size fits all. And so we encourage you to at least be a little bit flexible in these times as much as we can while ensuring the safety of others as we go forward. Next slide. The other thing that we want to talk about is you probably, if you have employees and you're talking about bringing employees back into the workplace, you want to talk about who do we recall? And the most important thing you do when you talk about who to recall is have a plan. Have a plan in place for who you're going to recall first. It's probably going to be your critical infrastructure. Folks, especially in your IT and security department, would come back first. Then folks that may be operations, HR, management, and have tiers if you're large enough and have a large enough business. Bring back people back in tiers. You have the necessary critical infrastructure. Then you have your performers, the ones that are really going to jump in and perhaps multitask and be cross-trained. And then you're going to decide whether you want to bring in maybe a third tier of the rest of the people who are out, depending on how large you are. But have a plan and make sure that that plan is as objective as possible. The criteria is objective. The more subjective you get on bringing people back, the more likely it is that you could get a claim. And I'll give you an example. When the governor's order came out and it said people who were over 60 or 65 should stay home. And then all of my clients called and said, Bill, you know what? We're going to make it mandatory. If you're over 65, you cannot come into work, even though everybody under 65, it was discretionary. And I said, no, don't do that. That's a big fat age discrimination claim waiting to happen. You can't just say, just because of that classification age, that you must stay home. What you do say is you inform what the risks are. You say, look, the governor has said, hey, you're in a protected classification. The CDC says you may be more prone to the dire effects of COVID-19 and the virus, but you cannot mandate just because of age that someone stay home just because they're 65 or older. And I think about people that I work with. I work with several lawyers who are 65 or older, and I think about, they're in great health, and they would say, I can work, I can come in, I'm fine, I understand the risks. Make sure that we're educating people on the risks, and that at the end of the day, if they still want to come in, let them come in, but they have to be educated and understand the potential ramifications of coming in. But you can't just keep them out because of the age, or else you're just going to get an age discrimination claim. And then have a process in place. If people have questions, make sure they understand the process and that you can explain it to them, and again, be as objective as possible. And then also make sure that if you have an HR department, you get HR involved. Next slide. And so the best time now to have new policies, or put in new procedures, or have new training, or have people sign off on things, is when they come back to work. This is a good time to get people to come in and put in a new policy, because now they're coming back to work. They're going to expect changes in the workplace, certainly from a safety security standpoint, but you want to make sure that if you're going to institute new policies, it's best to do it right when people start to come back. The other best time is the new year, when January 1st rolls around. Folks expect things to change. They expect their pay to change. They expect policies and procedures to change. These are just natural times to put in new policies and procedures, and do it now. And think about, if we're going to continue to have a remote workforce, what's our leave policy going to be, and what does it look like? And how do we tell if people are going to be taking leave or not taking leave, or are people at home actually just taking leave but pretending to work? So we need to make sure we have a mechanism in place to understand that. Workplace safety, if they come in, make sure you have a policy and a protocol for safety protocols. We'll make sure you're at least social distancing. If you can't social distance, certainly wear masks. You should have a mask requirement for work. If people say they can't wear masks, then maybe there's that face shield alternative. And if they can't wear a mask or a face shield, then you may want to reconsider whether somebody can come back into the workplace, because you have to think about the safety and security of the people around you, and what they're going to face if they come back with someone who refuses to wear a face mask or a face shield. And then, is your attendance policy going to change? If someone's working from home, or you have a remote workforce more than you had before, will you need to look at your attendance policy again and determine what qualifies under that attendance policy for either an absence or a tardy or a late from lunch? And how do you keep track of that? If you have work from home obligations, you might want to think about, what do employees need to work from home? Here in Florida, you don't have a requirement necessarily to make people, or to buy people, everything they need, including internet, to work from home. But in other states you do. In California, for example, if someone needs that Herman Miller ergonomic chair, you've got to buy them that Herman Miller ergonomic chair as an accommodation under the ADA and pay for it in California. You have to pay for internet service, at least the pro rata share of internet service that folks use in California. Anything the employee is required to do from home, then that has to be subsidized by the employer. And then, do you want to change your dispute resolution policy? Do you want to institute an arbitration agreement? Maybe this is the best time to do it. You've been thinking about it, and you're bringing people back, and now you're going to have a new policy to go with that new handbook that you've looked at. But make sure that when people come back, it's also a great time to re-sign off on the old policies, especially sexual harassment, discrimination, retaliation. Bring people in and say, look, we just want to make sure, these are our policies, these are reporting mechanisms. Go ahead and read through it. And if you read through it and understand it and you don't have any questions, go ahead and sign off on it. Not only are you reminding people that you have policies and procedures in place to respond to issues in the workplace, but you're drawing a line in the sand. If they sign that and they don't say, hey, you know what Joe did to me about 6 months ago, I never did report it because I didn't want to make waves. But if nobody says anything like that, then when somebody does come up and say, you know what Joe did to me 8 months ago, and you say, wait a minute, 2 months ago, you signed off that harassment policy and you understood it and you didn't have any questions. Why didn't you bring up Joe back then? So we draw a line in the sand. We have an opportunity, at least, to fortify our defense should a claim come down the road. And most importantly, safety. Think about safety first. We have a lot of folks that are doing the right thing and putting in the right policies, but then we go into the break room and everybody's sitting together and they don't have masks on or they don't have shields on. Well, we've got to enforce our policies with progressive discipline, because heaven forbid somebody gets and contracts the disease and they sat in one of those pods in the break room and they were together without their masks on. well, that's potentially a claim against the employer. So we want to be very careful to make sure that we're not only do we have the policies, not only do we post the policies in the workplace, and we post the procedures that we're using to keep and maintain a safe workplace, but we're also enforcing those policies through our progressive discipline system. Next slide. So also have a plan and educate employees. Employees are going to have questions. They're going to be concerned. Make sure that the employees understand that what you're doing is enforcing and maintaining a very safe workplace. Safe employees are going to feel comfortable. They're not going to be as concerned about catching the virus, and they want to make sure that they're in a comfortable environment. And we want to make sure as an employer that we've taken steps to maintain the integrity of our workplace. And that plan should be posted everywhere. You should have posted that if you feel like you have a fever, if you're experiencing any symptoms of the virus, do not come into work. I have to sign off on an application every day on my phone that comes in a text message every day. And it says, hey, if you're going into the office, then you need to attest that you're feeling good. And so I do. I do it every single day. And at least that I have that track record. My employer has that track record to ensure that we are maintaining safe environment. If someone says, hey, you're not doing enough, then at least we can show them the track record of what we're doing and the procedures that we have, not only that we have in place, but that are being followed every day by folks to ensure the environment is maintained on a safe basis. And employees that have safety concerns, well, they should come talk to you about it. There should be a reporting mechanism. Maybe they want to stay home. We'll talk a little bit about what if they want to stay home, but we don't have that opportunity for them to stay home any longer. But we want to be very flexible. I will say, and I rarely do this, but the agencies, the EEOC, the DOL, OSHA, certainly the CDC has been working overtime. The agencies have done such a great job of being flexible during this time, and that's an unusual circumstance, but even they have said, look, we're all in this together. We want to be as flexible as possible. Sure, we have policies and procedures in place, but we're also human, and we don't want to discount the human factor and when we're making these decisions. So someone says, look, gosh, I know I'm an able-bodied person and I don't have COVID, and I'm not living with anyone who's in a protected classification who is more susceptible to this disease, but doggone it, I don't feel comfortable coming back to work. Well, we want to think about what we're going to do in that situation. Are we going to give them a little bit more leave time and let them come back when they're again able to come back and perform the essential functions of the job? Or are we just going to fire those individuals? And that's really a case-by-case basis, but I would lean toward maintaining the employment as much as you can from a practical standpoint and not resorting to termination until you just have to do it. It's like Roadhouse, right? Patrick Swayze, you just be nice until it's time not to be nice. And some people we bend over backwards for, and we've done everything under the sun for them. Those are the ones that come back and sue us, unfortunately. But if we show a little bit of flexibility, then the courts are going to look very kindly on those things. Next slide. And then in your safety plan, screening is so important. If you don't have a health screening process for people who have to go into the workforce or at least be traveling, make sure that you have a screening process in place, and that process is written down and people can refer to it when they need to. Certainly, if you have a workplace where there's a lot of individuals that come in each day and multiple times during the day, perhaps, make sure you have a cleaning protocol to make sure that we have a heightened process for cleaning up equipment and desks and even computers and keyboards and monitors, so that the employees feel like that it's a more sterile environment, an environment where COVID is not something that's likely to lurk. And then make sure that we have protocols for washing hands, social distancing, especially in gathering areas, whether it's the water cooler or the lunchroom or the coffee pot, whatever it is. Make sure that we have a plan in place and we're enforcing that plan for maintaining social distancing, and make sure you have masks on hand. Employees are going to forget masks. I often get out of the car and think, man, I got to go back and get my mask, because you just don't think about it. You still don't think about it on a daily basis. So have those masks on hand. For employees who can't wear masks, we want to make sure that we have face shields, at least some alternative before we say, nope, you just can't come into work if you don't have a mask, or if you can't wear a mask or wear a face shield. But remember, we still have that interactive process requirement under the ADA if someone has a condition that would be considered a disability. And we're not really physicians or medical practitioners. So as you probably know, the ADA stands for Assume Disabled Always, and we want to err on the side of giving that accommodation if we can, and if it's practicable from a business standpoint. Next slide. temperature screening. So the DOL or the EEOC has come out and said affirmatively that employers can do temperature checks. Not everybody should be doing them. You don't just want to say, okay, the folks in maintenance or the folks in food service should be doing these temperature checks. Just anybody who happens to be on the door. Try to keep it minimal to HR if you can. If you have any medical personnel, to those medical personnel, remember these are still medical records, and we want to keep those maintained in a safe and secure environment. Symptomatic employees should not be allowed to enter the workplace. No one's going to want them in the workplace. They don't want to be in the workplace because they certainly don't want to potentially bring even a cold or something in. I mean, now I think I go out and somebody sneezes and you're like, oh my gosh, what was that? And where are they? And am I, more than 20 feet away? And require workers to report if they feel sick or have symptoms or test positive, certainly for the virus. You can have a written questionnaire for returning employees. A lot of employers have sent the questionnaire through an application or on their intranet site that folks can log in and say, yep, I'm ready to come back. This is the schedule that I'm ready to have, and I'm symptom free. And then, you can do the COVID-19 testing. The question is going to be when there is a vaccine available, if we're required or if we can require employees to get vaccinated. The EEOC has not definitively answered that question. I think that we'll see a little bit more information on that as vaccines continue. There are at least 2 vaccines in the 3rd phase of testing, which is a good sign. I think Moderna and Novavax are both in phase 3 and showing positive applications in the vaccine. So it remains to be seen what's going to happen, but we will keep you informed on what's going to be required and what's allowed to be required when it comes to vaccinations. Next slide. And then we want to think about, and I touched on this just a minute ago, what if somebody doesn't want to return to work? Well, we have to think about the legal obligations that we have as an employer. Consider the leave obligations. If someone can't return to work, we want to know why. Is it because they are a person who has a condition that's more susceptible to the dire effects of COVID? Is it because they're living with someone who has a condition that's more susceptible to the dire effects of COVID? And so if they want to take leave and they qualify and have a serious health condition, well, FMLA would apply. If they have a condition themselves that is some issue that would make them more susceptible, or it's somehow they have, certainly if they have COVID and affects, their mental faculties, or fatigue sets in, things like that, it could qualify under the ADA. And then, of course, we have the FFCRA, the emergency paid sick leave, or the EFMLA, for those 6 prongs that qualify under the EFMLA. So keep in mind, there's a lot of opportunities for leave. But here's really the issue. Joe says, I don't want to come back. I don't feel like coming back. I don't think it's safe over there. And you've taken all the protocols and you have them in place, and people are social distancing and people are wearing masks. And Joe's concern really isn't something that is grounded in fact. And so you say, look, Joe, I can't afford to hold your job, and you don't have a condition that qualifies you under the FMLA or ADA for leave. And so you have to decide, are you going to hold Joe's job available until there's a vaccine available? Or are you going to say, I just can't hold it, and tell Joe, we like you, Joe, but when you feel like you're able to come back into the workplace, we're going to go ahead and administratively terminate you, then go ahead and reapply. And those are the case-by-case bases that we want to consider and err on the side of not terminating, but we have every right to terminate. And so there's a lot of case law out there now, at least some case law starting to come in, and the EEOC has basically said, COVID is not a get out of work free card. And so you still have to have a condition in order to justify staying home and not be terminated. And then think about the ADA. If someone does have a condition under the ADA, is there a reasonable accommodation that we can do to make them feel safer in the workplace? This is what we did. We took people out of the workplace and we took away job duties because we had to, in order to remain viable, in order for our doors to stay open. And now we need people back in the workplace and doing those essential functions that we waived because we weren't able and we haven't been able to maintain our business the way that it's made to be maintained. The EEOC has talked about this. The Department of Labor has talked about this. You are not required. You are never required under the ADA to eliminate an essential function of the job. And now that you're bringing people back and people can come back into the workplace, you can maintain those job descriptions just like you had them before. You had to take away some essential functions, the ones that required being in the workplace, because you wouldn't have been able to keep the doors open if you didn't while you had a total remote workforce. But now you can bring people back and you want to enforce those essential functions. Because when Joe says, hey, look, you let me work from home, and I know I had to be there because there were things that I had to do in the office, but you really waived that essential function when you did that. No, but you will waive it if you say, you're right, Joe, we're going to let you work from home now, and that's not going to be an essential function of your position. And if you do that for Joe and you take away that essential function for one, then that may not be allowed to be an essential function for anyone else. And we want to make sure that we're very consistent in the way that we're applying the job duties and the job requirements. And then look at, can somebody continue to work from home? If not, then do we just put them on unpaid leave under the FMLA or under the ADA? And if not, then we want to follow our disciplinary procedure. If Joe says, I just didn't feel comfortable coming in. I thought I heard through a second cousin's boyfriend that Marnie was coughing in the workplace the other day, and doggone it, that makes me not feel safe. Well, that's not really a reasonable basis not to report to work. Are we going to use our progressive discipline policy and write Joe up, or are we going to fire Joe? And if we have a progressive discipline policy, I would urge you to use it and maintain that policy. And at some point in time, if Joe still refuses to return to work, then we're just going to have to say goodbye to Joe and for him to come and reapply when he's ready again to come back and perform the essential functions of the job. Next slide. And what if, and so here's what the EEOC said, and this was very recent, just a couple weeks ago. The EEOC said the employer has no obligation under the ADA to refrain from restoring all of an employee's essential duties at such time as it chooses to restore the prior work arrangement. So the pre-COVID time, you can put people back to work, same essential functions, and then evaluate any accommodation requests just like you would under the ADA. And they said just because an essential function was temporarily excused, just like we talked about, when the workplace was closed and employees were able to telework, it doesn't mean that that was a permanent excuse of that function. And now's the time to enforce the essential functions of the job with people coming back. Next slide. Let me talk just briefly about employment law update, and then Iggy's going to talk a little bit more about COVID. Next slide. So as many of you may have heard, the United States Supreme Court came back in the Bostock case. It was really a trio of cases, but came back in the Bostock case with regard to whether Title VII prohibits gay and transgender LGBT discrimination. Next slide. And the answer to that question was yes, it does prohibit that discrimination. 6 justices joined in the opinion, 3 justices dissented, with the majority opinion authored by Judge Gorsuch. Next slide. And what the court said at the end of the day was, in Title VII, Congress adopted broad language, making it illegal for an employer to rely on an employee's sex when deciding to fire that employee. We do not hesitate to recognize today a necessary consequence of that legislative choice. An employer who fires an individual merely for being gay or transgender defies the law. And so certainly I believe that Congress would have taken up the banner if the Supremes had ruled the other way, but it did go the way that folks expected. And so LGBT is a basis of sex discrimination under Title VII and therefore protected. Next slide. And this involved 3 cases. There were 3 plaintiffs, 2 gay men and a transgendered woman. Next slide. In the Bostock case, Mr. Bostock accused his employer of firing him after he revealed he was on a gay softball team. In another case, a skydiver alleges his employer fired him when he told a customer he was gay. And in the third case, a transgendered female told her boss that she would come to work presenting as a woman and wear a skirt required of female employees. Stevens was transgendered and previously presented as a man and got fired. Next slide. And the court went on to say an individual's homosexuality or transgender status is not relevant to employment decisions. That's because it's impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual on the basis of sex. Next slide. And so here's another one of those opportunities that if you're going to change your policy, it's probably a good time to do so, and you haven't added in LGBT plus as a category in your EEO policy statement or your anti-discrimination, anti-harassment policies, then go ahead and do it and have people sign off and include those reporting mechanisms. And some of your state protocols, if you're not in Florida, may be even more restrictive. Florida will protect against those things in general as well, but include sexual orientation and gender identity in your policy language to make sure that it's in there, and then include it if you do training, which you're required to do in some jurisdictions, that you include sexual orientation and gender identity discrimination in that training. Next slide. And then what about dress codes? Do we need to eliminate, think about it, do we need to eliminate gender-specific dress codes? Employers can have gender-specific dress codes as long as they're not arbitrarily enforced or unlawfully favor or affect one gender. And so think about whether your dress code is adhering to a stereotype, long hair for women, right? Not long hair for men. That may be problematic, and certainly in today's environment. Eliminate gender-specific dress codes if you can, and grooming standards, and implement gender neutral. If you have long hair, make sure it's well kept in a ponytail if it's beyond your shoulder, something like that, that would apply equally to both genders. And then revise the policies to focus on professionally appropriate attire for the office and not gender specific policies. Next slide. And so what we're going to see, and I think what we'll continue to see from Bostock, are more lawsuits and more internal complaints. We certainly had some lawsuits that were recently decided before the Bostock opinion came out that said, hey, transgender LGBT is not protected under Title VII. A lot of those folks who were on the wrong end of those lawsuits have asked for reconsideration, and some of the courts had put lawsuits on hold pending the end of what the outcome of Bostock was. And so those lawsuits have now restarted and continue in the courts. So keep in mind, if you have any of those issues, they should be part of your reporting policy and that those things are protected. Next slide. And so now I'm going to hand it off to my colleague, Iggy, and he's going to take you home, starting with the FFCRA. Iggy, take it away. Tell them a little about yourself.
Hey, everybody. Thank you so much for having Bill and I. We're excited to be able to talk to you all. Like Bill said a little bit about myself, I'm also a shareholder here at Ogletree's Tampa office, also have a national practice like Bill. And, you know, we deal with these types of issues every day. And so what we're hoping to, like Bill indicated, our goal here today is kind of give you guys an overview of where the state of the law is from an employment perspective. What my portion of the seminar is going to cover more is where the employment law cases are going and what we're seeing. As you can imagine, COVID has really upended the whole landscape in the world of employment law. Employers are having to deal with practically constant, daily, practically changes in laws and regulations on how to deal with COVID. And keeping up has been a struggle. And as you know, the pandemic has continued. Now we're starting to see some case. You know, first you saw the pandemic start, then you saw the regulations come in, and now we're starting to see the lawsuits come through that we were all expecting were going to be coming. And so I just want to give you an idea of what those are. So one of the first ones we've seen is Jones v. Eastern Airline. You know, and this addressed some of the issues that folks had questions about. One is that there is no charge of discrimination requirement to be able to bring a cause of action under the Families First Coronavirus Response Act. That is the name of the statute that covers all the new paid leave provisions related to COVID. There is no requirement, no administrative prerequisite to bring a charge of discrimination like there is for many different types of discrimination suits. This statute really tracks more the Family Medical Leave Act. It's seen as an expansion of the Family Medical Leave Act. And Family Medical Leave also does not have the charge of discrimination requirement. The remedies are the same as the Fair Labor Standards Act, as well as Family Medical Leave Act. You're looking at actual damages, your lost wages that you incur when you lose your job because of according to your claim, because of your wanting to use the Coronavirus Relief Act. You can also get liquidated damages, which is an equal amount to your lost wages, and you can also get your attorney's fees, which is really the tail that that wags the dog in a lot of these cases. A lot of times the attorneys end up getting more money than the individuals if the individuals don't have a lot of lost wages. But the litigation goes on for a long time, and if they ultimately prevail, they could get a lot of attorney's fees. So don't be fooled into thinking that if an individual doesn't have a lot of damages, either they found another job quickly or you think their case is not worth a whole lot, that no attorney is going to want to take it. Even if they get some money, any money, a little bit of money, they're entitled to their attorney's fees, which, like I said, is really the tail that wags the dog. It's also important to know that under the Families First Coronavirus Response Act, I'll just call it the FFCRA for short, you also have individual liability against managers, just like you can be brought under the FLSA. So that's also something to keep in mind. You'll see that when individuals bring these claims, they'll bring it against the company and they'll also bring it against the individual managers. So something else to be aware of. Next slide, Matt. All right. Another issue that's come out of the Southern District of New York, one of the courts there invalidated certain portions of the regulations that the Department of Labor created to help enforce the FFCRA. And the main thing that the court invalidated was the definition of healthcare providers, because under the FFCRA, if you're a healthcare provider, you could potentially be exempt, and meaning that was a reason that employers can use to not award the paid leave benefits under this statute. There was that exemption for healthcare providers, and the DOL had made the regulations defining that exemption quite broad as to what constituted a healthcare provider. The Southern District of New York found that those definitions were too broad. And so if you're going to use the exemption of the healthcare provider under the FFCRA and you're going to not give paid leave to an individual claiming that they are exempt from those benefits because they're a healthcare provider, you have to follow a more narrow definition of what constitutes a healthcare provider. And the DOL has narrowed that definition. They basically followed Family Medical Leave Act. And so if you are an individual who is employed to provide diagnostic services, preventive services, treatment services, or other services that are integrated with and necessary to the provision of patient care, then you potentially are a healthcare provider and are not entitled to the paid leave requirements of the FFCRA. A few other I would say more minor things that the DOL regulations also clarified one is you're only entitled to FFCRA leave if there's actually work available to you as an employee. If there's no work available, then you're not entitled to get that paid leave at that time. You need to get the employer's approval to be able to take that leave. And you also need to provide the employer with documentation in support of that leave when it has been requested of you. So other things that that the Department of Labor wanted to clarify, we'll see if there's more litigation as to those provisions and if any courts strike those provisions down and if those have to be revised, and we'll keep you up to date on that. As I indicated earlier, I've really never seen anything like this in my 20-year career, that the law is changing practically daily with these things between the court cases, the regulations, the statutory language. It's tough to keep up with. All right, next slide. Okay, trends that we're seeing in terms of litigation. What are we seeing arise in? Unsafe workplace claims. As Bill alluded to before, claims by employees that their workplace is not safe, that they don't want to go to work, that they're putting their health at risk if they go to work, and bringing claims against employers for those types of things. Also, as usual, we have retaliation claims, discrimination claims, and wage and hour claims related to time off that employees are taking for leave, or work that they performed in leave, or objecting to come into work and then being terminated. All those have led to retaliation, discrimination, and more wage and hour claims. Next slide, Matt. Okay. Things that employees are bringing against the employers, and Bill alluded to this one as well. If you are an employer that didn't close your shop during COVID, or you're not providing PPE, personal protective equipment, to employees, if you're not properly sanitizing or cleaning or spacing to protect your workers, if you're not complying with state and local orders, I mean, those are all types of claims that employees are bringing against employers now. So it's something that you want to be aware of, that's out there, and you want to make sure that you're following these things. And we'll talk about that in a little more detail. Okay, next slide. As I alluded to in the last slide, complaints regarding unsafe conditions are one of the main things that we've seen growing a lot, and they've come into lots of different types. One is, employees complaining that the employers are not protecting their workers and not enforcing the different types of regulations that are out there. It's not enough to just have a policy in place. If an employee is able to show that as an employer, you're really not taking it to heart and you're really not enforcing it, then they could still bring causes of action against you. If you're not following the state and local guidance, that's one of the easiest things to prove for an employer, that, hey, this is what the guidance is. They're not doing it in our workplace. And that makes it very easy for a jury to find that you're not providing a safe workplace for your employers. Then you've got refusals of employees to return to work, and as Bill talked about, you got to deal with those on a case-by-case basis as to how you want to handle them, versus whether the employee is disabled, is not able to perform a major life activity, which is the definition of disabled under the ADA. And as Bill indicated, it's a lot easier now to be considered disabled under the ADA. You've got to deal with those employees differently than those who are not covered under the ADA and just have an unfounded fear of returning to work based on rumors or innuendo or whatever they saw on TV. So that's another thing to be aware of. Other things to be aware of: leave requests is another type of cause of action that employees are bringing when they're not getting the leave request that they believe that they're entitled to, and they believe that they had a valid reason for getting the paid leave. The employer didn't give it to them. That's another cause of action. So, these leave requests that employers are making under the FFCRA, you have to take seriously, because if you make the wrong choice as to whether someone is eligible or not, that can lead to litigation. Also, we've seen employees bringing whistleblower type claims against employers because employers have misappropriated funds from the CARES Act. If you recall, the CARES Act was that huge federal legislation where literally billions and billions of dollars were given to businesses who were suffering from the effects of COVID-19. And I'm sure we've all heard in the news, some business owners that haven't used those funds as they were intended to be used. And you've seen employees bring whistleblower type claims based on those things. And if they suffer, when an employee has complained about the use of those funds, they get terminated and they bring a whistleblower claim. All right. Next slide, Matt. Okay. Disability discrimination claims, another type of claim that we have seen grow. And as Bill talked about before, you're dealing with the issue here of whether you're going to accommodate somebody who's potentially disabled under COVID-19. And you have to decide first, if potentially a person is disabled under COVID-19. To be disabled under the Americans with Disabilities Act, you have to have a limitation to a major life activity because of your alleged disability. So as we all know, COVID doesn't treat everybody the same way. Some people show a lot of symptoms and are really limited in major life activities, and other people show no symptoms at all and are just going on with their life. So those people are going to have a harder time claiming that they're disabled, but the ones that are having symptoms are going to have an easier time. And there's different ways that potentially someone can bring a cause of action based on disability. One is you're actually potentially disabled. Another is because there's a record or history of a disability. Another type of claim they could bring is that you didn't accommodate their disability. So you have to take those claims for accommodation seriously. When you have an employee that claims that they have the coronavirus and they're exhibiting symptoms and that they need an accommodation, you have to take part in the interactive process to determine if an accommodation is possible. Now, there may not be an accommodation that's possible. As Bill said, you do not have to give up on essential job functions to be able to accommodate somebody, but you do have to take part in the interactive process and make a good faith effort to determine if there is an accommodation possible for that individual. You can't just disregard it. All right, next slide, Matt.
Getting close up on time. Just want to let you know.
What's that?
I think we're getting close to a stopping time to allow people to go to their next session or do whatever they need to do.
Okay.
Put it up there.
When do we want to stop? At 150?
Slides, yeah, or 50, 51.
Okay.
Time. I didn't know if there's any
We'll just
one
cover
or
a
two
couple more
things.
slides, and then I'll stop at that.
Okay. Perfect.
Okay. All right. So real quick, couple more last slides for you guys. Title III, disability access cases. And what you're dealing with here is employees who are disabled and claiming that they could not take part in the same types of work activities because the employer didn't make their workplace accessible to them. Typically in the past, we've seen these cases involving, not having the right door handle heights, not having ramps so disabled individuals could come into your workplace. Now we're seeing more on the websites that your website is not accessible to disabled individuals. And in the COVID realm, what we're seeing is that employers are not making an effort to adjust their PPE equipment or their policies that are dealing with COVID to address those employees that are disabled, making exceptions, making alterations to those policies for those potentially disabled individuals. When employers are not making that kind of effort, you see these causes of action. All right, so we'll do one more slide. You can turn one more slide, Matt. Great, thank you. So, and lastly, age discrimination. Dealing with employers who are making decisions as to what employees bring back. And if you decide not to bring back your older employees, or if you have a neutral policy that has a disproportionate impact on your older employees, then you are running the risk of an age discrimination claim. So it's something that you want to keep in mind when you're deciding what employees you're going to furlough, what employees you're going to bring back from your furloughing. What do these employees look like? I mean, not just their age, as I described in that slide, but you also want to look at, what is their race? What is their sex? Keep in mind those types of things so that the policies that you have for furloughing or bringing employees back doesn't disproportionately hurt one group. Because, employers hear about these things, employees hear about these things, they all talk to each other. The word gets around, and if it starts to look like one protected category, one protected group is being disproportionately impacted in your policies of letting employees go or bringing employees back, that's where you start running into problems with lawsuits and charges of discrimination. And these what we call disparate impact type claims, where you have a neutral policy that it disproportionately affects one minority group, is something that the EEOC takes very seriously. And once they find out about this and they get involved in the charge phase, then you're having to produce all kinds of information about your hiring practices, your furlough practices, your rehiring practices, and it's a lot of work for employers. So in keeping with time, I'm going to go ahead and stop it there, and I'll turn it over to Matt if anyone has any questions.
Thank you so much, both Bill and Iggy. I think we need to make space for folks to get set up in this room. But if I saw some in the Q&A, some question about the CARES Act. Hopefully that's been answered sufficiently.